The next case is Keith Smith versus the City of Detroit and Merlot Construction Company.
Good morning, Your Honors. May it please the Court, Amanda Warner, here on behalf of the plaintiff, Keith Smith. And I'll allow questions whenever you're ready. I'd first like to point out that there was no finding in the trial court on whether or not Defendant Merlot had possession and control of the area of land where Mr. Smith was injured at the time of the injury. And then when we go up to the Court of Appeals, we find that the Court of Appeals has essentially acted as a fact finder and said Merlot did actually exercise dominion and control over the sidewalk at the time of the injury, merely because plaintiff was alleging that this happened on a condition of the land. So right there we have an issue where the issue of whether or not a defendant has possession and control is a question for the fact finder. We also have an issue here where we have a contractor who was assigned to do work on this sidewalk. They proceeded in doing their work, and then they left the construction site. They took all of their materials, everything, no semblance of any presence there by the defendant aside from this hole, and left and didn't return for 3 days to complete the work. So you have no signs, no barricades, no cones, no tape, no tools, no machines, no construction signs, no employees, no contractors, no workers, nothing here to show that the defendant had actually exercised any dominion or control over this area of the sidewalk at the time of the injury.
Well, he'd removed the concrete in the first place, right?
I'm sorry?
They'd removed the concrete in the first place. Doesn't that show some extent of exercise of authority or domain?
They did. There's no question that on October 9th, they were exercising some control over this sidewalk. However, 3 days later when the injury occurred, and every day in between then up until the 15th, there was no exercise of any dominion.
Did anyone step in? I mean, did anybody else exercise possession or control of the premises after? We know that they removed the slab. We know that they came back at some point and completed their work. So we're in the sort of broader realm of their work. Did somebody else come in and exercise possession or control of the property in that intervening time?
It didn't seem as if anyone had exercised dominion control to the exclusion of all others. During that time, it was still being used as a public sidewalk. People were still traversing it. It was still under the city's control. Ostensibly, obviously not the city's responsibility to correct this condition because it hadn't been present for 30 days. But certainly.
So under the restatement, where I think it's 2B, a possessor is someone who has been in occupation of land with intent to control it if no person has subsequently occupied it with the intent to control it or not. Would you agree that Merlot falls under the facts of this case in that definition?
I would agree that there's a question there on the timing. So if someone assumes possession, are they now in possession until somebody else takes possession, until their work is done and they're now giving it back to the city? Do they have no obligations during this time to, what is their obligation when it comes to possession and control and actually asserting it? When this court has told us that possession and control is the actual exercise of dominion and control.
So it's not that they don't have any obligation, it's that while that condition exists where they've exercised control, nobody else has subsequently exerted control over it, they have an obligation akin to the premises owner, the duties that arise from that, right?
I
mean,
would say they have an obligation under ordinary negligence, just the duty to use due care when they started working on their project on the 9th, and then when they left and they gave up their possession and control, they left an open hole. They didn't close the sidewalk. They didn't warn that this area was hazardous or dangerous. They didn't put up any lights to make sure that it was lit at all times because conditions change between day and night.
Is the absence of doing those things evidence of giving up the control, though?
The
You
absence,
premise the whole thing on when they gave up their control. That's the question, though, right? And so you articulated these factors. Are these factors that show that they've relinquished control?
I think they can be, with regard to the signage itself, that they didn't put anything up or post or barricades or cones or tape or close the sidewalk. I think they could have maintained possession by doing those things, and they didn't do that.
So the failure to do so suggests that they've relinquished control?
I would say it's a factor that could be considered to show and to explain to the jury that they weren't in possession at the time of the injury. Yes.
So their possession on a continuum, they could assume possession, say in control when they removed the slab. They could give it up by leaving for the day without proper barricading and reassume it again when they come back to put it in, to, re-put the slab in. I mean, so it can change almost, even if they leave for lunch, say, or something, they give up possession and control. Is that the sort of proper inquiry, or is it they assume possession and control when they, contracted to do the job and actually began performing through the point where they completed performing the job?
Well, I think that's a concern here because if they contracted with the city to do this work, does the possession start when the contract is signed? Does it start when they start moving materials there? What happens if somebody is using the sidewalk during the time where they could have started working on it but didn't? And then there's a question of, so they've started this project, they've been working on it, and now let's say they're not getting paid, so they stop working on it and quit and they're done. Are they not liable for the work that they've completed?
Well, here we don't have, and I understand that, again, when you're talking about the change the facts, and you could get perhaps a different analysis of when somebody has possession and control and when they give it up. But here you don't have, this isn't hey, I signed the contract, and that's when this accident happened. They actually exercised possession and control by removing the slab, and they had not completed that work, had not stopped because they weren't getting paid or anything. It happened sometime from when they started to when they completed the work.
That is correct.
Okay.
But it is our analysis that even though they had started work and hadn't completed it, they had relinquished some form of, not their right to control or possess the area where the injury occurred, but they weren't actually exercising dominion and control at the time of the injury. And in fact, defense has even stated multiple times, the trial court and the Court of Appeals, they admitted that they didn't have possession and control, so as to avoid any sort of liability, because they believe that it's strictly a premises case. And also, just as a quick final point, the exercise of possession and control is twofold as well. It's both possession and control, as this court has instructed us before. And I'll withhold the rest of my time unless there's any other questions for rebuttal.
I don't see any. You may.
Good morning. If it please the court and counsel, John Schutza, appearing on behalf of Merlot Construction. I would like to begin by addressing the point that the court directed us to in the order granting leave, which is to compare Cavanagh versus Fire Equipment Company and Orrell versus Unirac with the Frame versus City Sewer peremptory order. I think all those cases can be reconciled. Although the facts in Frame, being a peremptory order, are scarce, when you look at the Court of Appeals opinion, it flushes out the facts a bit more. We had a situation in Frame where there apparently had been a contractor there doing work on the drain in the meat department of a Meijer store. However, on the day that the plaintiff tripped and fell, apparently on a raised drain cover, there was no ongoing work by the drain workers, and in fact, the Meijer store had reassumed complete control of the area. They were using the meat market. In fact, the plaintiff was working in the area carrying a tray full of meat when she fell. That's a distinctly different situation than in Cavanagh, where you had an ongoing construction project by Fire Equipment Company, or the situation in Orrell, where there had been a fire and the contractor was in the premises owner's parking lot affecting repairs when the plaintiff fell and slipped on ice. The distinction being, or rather the point being, as the Court of Appeals in Cavanagh noted, this court implicitly in Orrell recognized the principle that is set forth in Section 384 of the Restatement of Torts, that while a contractor is on the lands of another, erecting a structure or creating any other condition, they're subject to the same liability and able to raise the same defenses as the property owner, and the key phrase being, while the work is in his charge. In both Cavanagh and in Orrell, the work was in the charge of the
Counsel,
contractor when the plaintiff was
just a
injured.
question, what if you had left the site for 6 months under the same fact pattern? Would that make a difference? Work wasn't completed, there was no barricades, there was no warning, no signage, none of those things, but the work hadn't been finished and there was a duration of time that elapsed. Would that matter?
Depending on the facts, it might. I mean, if there had been a work stoppage in the union, for instance, of the workers that had been working, say, on the project, and they just completely abandoned the project and walked away, that's a different situation, I submit, than we have in our case.
So should the court then do an analysis as to why the work wasn't being done? Or, I mean, how do I look at this? Like, how is the court supposed to approach this? Does it matter if there's a work stoppage or not? Like, do the facts that go into why a work stoppage took place or why the work wasn't being done matter? Is it a time sequence? Like, what's the factor? What's the test I should be using?
Well, I think the test is provided, again, in Section 384 of the restatement, where it says, while the work is in the charge. And I think that the fair meaning of that phraseology, and as interpreted in the 20-some-odd cases from other jurisdictions that have applied this section of the restatement, is the work is ongoing. It's ongoing.
But could it be ongoing without a duration?
I don't think that's ongoing, no. I think you're correct. I mean, if a contractor walks away from the job for 6 months, that doesn't indicate an ongoing project.
Mr. Schutza, can you tell me, do you read Section 384 to be consistent with sub B of, what is it, Section 57, that you know, the person has been in occupation of the land with intent to control it, and no one has subsequently occupied it? Is that consistent with 384 that says it's within his charge? you're not suggesting, I think the example given that I've signed the contract, is that within the contractor's charge at that time, regardless of whether they've actually exercised control?
No,
or
I don't
can
think
they-
so. I
Okay.
mean, until they actually go on the premises and begin the assigned work, they're not in charge of the premises. But clearly here, we were in charge. You know, no better illustration, I think, of the fact that here Burlow Construction was in charge is as acknowledged by the plaintiff who maintains we should have been the ones to erect caution tape and barrels and sidewalk close signs. What right would Burlow Construction have had to do that had they not, in fact, been in charge of an ongoing construction project? So I think there's little question that there was an ongoing project here and they were in control of the premises. You know, it
But
goes.
Counsel, what about the fact, I mean, isn't there a factual dispute as to the fact that others did have access to this project?
I don't-
Was it just exclusively your client, or wasn't there some other conjecture that, you know, the city and, you know, other entities might have had, you know, played a role in this as well?
No, I don't, I'm not familiar with any evidence in the record suggesting over this course of whatever it was, 4 days or so in October, that anyone else was involved with doing anything in this area of the 2 missing or removed sidewalk slabs.
Okay. Does it matter if anyone else had access to it?
I'm sorry, Your
Perhaps
Honor?
maybe if not, perhaps if there wasn't work being done, would it matter if other entities had access to it, if there was an access question?
Such as
The
members of the public?
city, or the city perhaps, if the city has access, or the city has interest in doing work on it, or things of that nature, or if other people had been subject to the premises as well, would that matter?
I think that goes to the section of the restatement earlier referred to by Justice Cavanagh, which is one is in possession if one has been in possession and no one else has subsequently exercised possession over the property, the first party is still deemed in possession.
I see, okay.
If there are not any other questions, thank you very much.
Thank you very much.
Just a quick point on the matter of the Section 384, the Restatement of Torts, and this idea that you can loan these possessory rights to someone else so that those defenses can also be available to those defendants. Does that mean that that original possessor then transfers its rights of responsibility to the contractor? And in this case, we have a governmental entity who has a duty to keep the sidewalk in reasonable repair, fit for safe and convenient travel. Is that now something that the defendant is required to do? And I don't believe that that was discussed in the trial court or found to have taken place. And then we also have the issue of the definition in the restatement. We don't have any explanation here. This court has never adopted that on what it means when it says when the work is in his charge. And I think here we have an ongoing construction project, but we have no work being conducted at the time of the injury. Thank you.
Thank you, counsel. The case will be submitted.